to the meeting of the local review body of 14th of October 2015. I can confirm that the meeting has been properly called and is quorate, and I would ask for chairman for this meeting.
Nominate Councillor Driver.
Good morning, members. Welcome to this local review body, 14th October. Can I ask for any Sederunt apologies?
There are no apologies, Chairman. All members are present today.
Thank you very much. And can I ask the clerk to take the review body through the documents and the papers for the meetings? Before I do, is this being recorded?
Yes.
Yeah, so if you've got any phones on, can you switch them off? And any declarations of interest? Ian?
Yes, item 4, that the original applicant back in 2014, I'm currently employing that agent, but I've no other interest.
Do you have one, Jim? No? No. Okay, thank you.
Thank you, Chairman. I can confirm there are 3 notices of review for consideration at this meeting, and they're set out in the papers before you. And I would also confirm that David Sutty is present today as the planning advisor and has not had any involvement in any of the cases before you. He's simply here to provide independent advice on matters of planning, policy, law or process. So, Chairman, you have the clerk's notes all in front of you. I won't repeat what's contained in the notes because you'll have all read them. I will pass now to you to take the members through the items today, please. Thank you.
Okay, thanks very much. David, do you want to go through the photographs first, if there is any?
Yes, thank you, Chair. These are just, in each case, the slides that you have for each item, respectively. So the first one, this is the site in Dalbeattie. So it's looking towards the application site from Balliol View, looking northwest, so you can see the site itself has got the road in, and the site is basically level. And again, this is looking this time northeast, and you can see the access that's been formed and the site itself. And the final slide really just shows the view of the south side of Balliol View. And I'm sure members will appreciate it, having read through the issues which are really before you today don't really involve the design of the property. That's not really been one of the issues, but for the avoidance of doubt, I did spot that unfortunately the papers that you have before you didn't include the elevations, the floor plan and the section through the property that should have been included. These are mentioned at the end of the case officer's original report in the list of drawings, so I have circulated these 3 drawings for members just so for completeness, so they are before you.
Okay, thank you very much. Members, I intend to go through each of the sections in the index of context for points of clarification. So as we go through the index of context, the notice of review is pages 5 to 11. Are there any points of clarification on that? Jane?
No, it is working now. Yes, I do. Can we be absolutely clear about the business of outline planning permission? The report on handling said that outline planning permission did exist, and then the update that was given in Patrick Hanna's letter, which I think is on page 23. Yeah, 23. Says that planning permission, outline planning permission doesn't exist, but there have been incremental applications, which indeed was the case. That certainly has been the case. So could I be absolutely clear whether or not outline planning permission exists or not, and does it actually matter?
Certainly from my reading of the case, I think what the appointed officer has said in paragraph 3 on page 23 is indeed correct, that outline planning permission did exist. There's no ambiguity about that. But because all of the appropriate reserved matters, as they were called then, were not submitted, then effectively that had expired. But what I understand has occurred is that individual full planning applications have come in for each of the relevant houses that have taken place. And accordingly, there's a planning history on the site, but there is no valid outline planning permission or planning in principle, it's known now, on that site currently. The site obviously does lie within the settlement boundary, but it is not an identified housing site for Dalbeattie.
Jane?
So can I go on then to ask, given that we've now got a completely new local development plan, all recently adopted, with actually, arguably, policies which would impact upon development such as this, can I ask then whether it is relevant that we don't have outline planning permission on the remaining plots?
Given that this is a full planning application, technically it is of minimal material consideration, I would suggest. It is obviously something which is of useful history, but you have a road layout that you can see from the slides there. This is a freestanding application for full planning permission on that piece of land that falls within the Dalbeattie settlement boundary. So to a large degree, the history has been included for background, but it's not make or break as far as the issues which are before you today are concerned. Because it is an H1 policy within the local development plan, which identifies areas for settlements, then this is within the Dalbeattie settlement boundary. It isn't an identified housing land. That is probably the material change that has taken place. This isn't, unlike the, as I understand, the Surety local plan identified this as a development site. That has been removed, but it is nonetheless within the settlement boundary, so each application just has to fall under OP1, OP2, OP3, all the relevant policies that are in the plan.
Okay. Going to report on handling and related correspondence, pages 13 to 19. Any points of clarification? No. Point 3 was observation of the appointed officer on the applicant's notice of review, pages 21, 24. We've heard some for Jane already anyway. Anything else? Pages 25, 27, comments of the applicant's agent on observation of the appointed officer. Any points of clarification? Ted?
Just on page 27, can you explain to me what the quantum of these contributions is a matter for LPA to determine, and now, since the review is an appropriate time to set these matters de novo, what does that actually mean?
What I consider the agent is saying here is basically the de novo bit is long-standing, that it is an application which has been determined by officers, but when it comes before yourself, the Scottish Government has given clear advice that you are determining this effectively from scratch, so it is open you to make a different decision. So that's the de novo bit. The quantum, I understand, will be really relating to how much financial value would a commuted payment be. Now, in terms of open space provision, you'll have noticed in the papers there is a clear figure for a commuted sum of £1,500 per property. There is, as far as the affordable housing goes, there's clear advice given on that as well. And it is not to give a specific financial figure for each application. I'd refer you to page 62 as far as that goes, where the second paragraph there says that the commuted sum in respect of affordable housing would be the difference between the open market value of the plot and the affordable land value of the plot. The onus would be on the developer to submit proposals detailing and justifying the value of the respective sum to be paid. So the reason why a quantum hasn't been given is it's up to the developer to come forward with that for the affordable housing element, for wherever there is for open space where a commuted payment is considered appropriate and necessary. The council has given a sum of £1,500 per unit.
Do we have any sort of idea about what that sum might be?
Personally, no, because that hasn't been examined by the case officer with the agent, as far as I can tell. And I haven't actually seen a figure come forward for that in the papers.
Okay, we'll go on to the planning application form dated 29th of August, plans and supporting documents, page 29 to 65. Any points of clarification? Decision notice from Dumfries and Galloway Council dated 12th of March 2000, pages 67 to 71. Any points of clarification? We then have the relevant extracts from the Dumfries and Galloway Local Development Plan, pages 73 to 269. Any points of clarification? Stephen?
Thank you, Chair. I think it's just an ongoing question I have in terms of how much material weight we would give what was effectively draft supplementary guidance, which was a lot of it would have been adopted after the date of the decision, but its draft status at the time obviously would carry some weight. So it's really just to get a wee bit of clarity on that.
David?
Again, it comes down to the de novo issue that you are considering this today, and therefore the status will have changed in one or two of these documents from when they were consultative draft pieces of supplementary guidance. As of now, all the documents which are in the agenda today that were at the stage they were determined merely consultative draft are now adopted. So therefore, you're considering it today, they are all adopted and therefore form part, as they're all statutory, they form part of the local development plan. So they have increased status as you're considering it today.
Okay, and then we have the photos which we've seen earlier on the site. Okay. Okay. You want to take us through that? No. Okay, so the grounds of refusal on page 71 is the proposal would create an identified need for developer contributions across the wider site, which has not been satisfactorily addressed, such that the proposal would prejudice the provision of affordable housing and open space contrary to policies OP3, H5 and CF3 of the local development plan. The applicant has requested the review to be dealt with on the basis of one or more hearing sessions. And in summary of this particular application, the officer's report makes it clear that outline planning permission exists. The reasons for refusal alleges conflict with policy and development plan suggest the need for developer contribution across the wider site. The applicants have no interest beyond their site. Planning applications have to be considered on their own individual merits. LDP policy H5 affordable housing adopts a threshold of 5 compared to the application which is for 1. LDP policy OP3 developer contribution uses the term identified need. The applicants contend that there is no such need. At best, there may be a theoretical need. However, that uncertainty would fail the test for assessing developer contributions as set out in Circular 3 2012. In terms of the wider site decisions relating to viability and costs were made at the outset 34 years ago. This compares to the Council's position set at paragraph 3.2 of the draft supplementary guidance, where developers need to take matters into account when purchasing development sites. LDP policy OP3 talks about exceptions that may apply. The supplementary guidance gives no exceptions. Historic development sites should be treated exceptionally. LDP policy CF3 also adopts a threshold of 5. The proposal is for 1 dwelling. And the officer's report provides that there are no concerns raised in relation to the location of the site and the site and the design of the proposed dwellings. We have the comments of the appointed officer on pages 23-24. And the comments of the applicant's agent and observations of the appointed officer are on pages 25-27. Some of the policies that are listed: Dumfries and Galloway Local Development Plan, OP1 Development Considerations, OP2 Design Quality of New Development, OP3 Developer Contributions, H1 Housing Land, H5 Affordable Housing, CF3 Open Space, IN9 Wastewater Drainage. Material considerations also include supplementary guidance, developer contributions, draft supplementary guidance on open space, and new draft supplementary guidance on affordable housing, which is now adopted. The main issues for the local review body to consider: does the proposal conform with the relevant development plans, LDP policies H5, CF3 and OP3? If not, are there any material considerations which would indicate that planning permission should be granted to the contrary? Does the proposal create an identified need for development contributions across the wider site? And should the proposed development incur a requirement for a developer contribution in respect of affordable housing and open space? And if so, what should this be? And having outlined the documents within the members' papers, it now falls to the LRB to determine whether it has sufficient information to consider the review. It is confirmed that no representation from any party will be heard today. And the options available are that we decide it has sufficient information before us to enable and to determine the review today. Request further information in the form of written representations. The LRB will be required to state precisely the information it is seeking and who must provide it. Resolve to hold a hearing, again specifying who will be invited to speak and on what matters. Or resolve to hold a site visit, accompanied or unaccompanied. This can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. And if the local body resolves that it has sufficient information and no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination, and the decision notice will include a statement of the term in which the planning authority has decided the case reviewed. If members are clear and if no further clarification is required, I'll ask the members if they want to lead the debate. And first instance, to lead the review body through the papers, which I've done, and decide it's sufficient information before it makes a determination today. So have we got enough information to make a determination today? Members?
Yes.
Okay. Any member wish to speak on this?
I suppose I just want to sort of continue to pick away and ask questions on this. It's about whether this is an individual application or part of a larger parcel. That's really, I think, the nub of it. I see, in affordable housing in policy H5, in all housing developments which will either individually or through phasing result in a development of 5 or more units, then there is a requirement. And the question is, if there is no outline planning permission for a wider scheme, and this is an individual plot, then what is the requirement on the individual to provide a commuted sum? Because it will be a commuted sum. And that's the thing I think we need to pick away at to find out whether or not it is appropriate.
It was certainly the question that I was going to be asking after members. So, David, can you?
I mean, that is actually the nub of the argument. And obviously the appointed officer has taken one view on this and the agent has put forward the other view. It is not a black and white case, I would have to say. When you would have if you have a look at page 35 of your papers, it clearly does show that there are a number of other plots which are in the same ownership, which is John Johnson Dalbeattie Limited. So That party is the developer for that entire scheme, and they have control of all of that land, to the best of my knowledge. So that being the case, yes, and I think the appointed officer does say there's considerable sympathy with the position of the applicant in these circumstances who does not own the application site or have an interest in the wider area. So clearly the appointed officer understood that matter, but had looked at the amount of remaining plots which are still here. And yes, there is a planning history on this site where permission had historically been granted, and maybe those things weren't required at those times, but things have moved on. The LDP came into being in September last year, and any new applications have to be considered against that. So clearly there is, in my view, if you look at that, there are going to be 5 or more plots developed within this area, and they're within the ownership of the same developer. The individual applicant for each plot might come forward, but my reading of this is that the concern that the appointed officer had is that where do you draw the line? This is the first application post LDP, and therefore we should be applying this and seeking to apply the policies that have come in since. That's really the nub of it. If the LRB are of the view that it is because of the history of the site and the amount of development that's taken place, versus say there are the number of remaining plots which still have to be built out, is it fair and reasonable to actually require such a donation to be made, or do you just say, well, okay, that's got history to it, we move on, and we'll do it to all new sites which are identified and have not started? Or you take the view that basically a line was drawn in the sand in September 2014, and when the supplementary guidance was then approved, and that should apply to all new applications that come forward.
Members? Just looking at and reading through the report, and I understand the sort of catch-22 situation that we could be in as a LRB. I think it's right that after the huge consultation that we went through to the local development plan, that we actually agree with the officer on this recommendation. But I'm open to members coming in and arguing the case. Jane?
Actually, I don't think I am going to argue the case, because the Stewardship Area Committee hated the business of incremental development. Absolutely hated it. It would be much, much easier had we been developing as a group in order to achieve good design, and not, as it happened, developer contribution, but we certainly wanted to see things being developed as a whole. So on that basis, the local development plan was a way of dealing with the problems that were going on in terms of incremental development. I don't think the applicant is looking for sympathy at all. I think he's looking for clarity and clarification. And I did look at this carefully, and I did have to understand about the outline planning permission and the development. But our policies now are quite clear that we expect developer contribution. And on that basis, Chairman, I am perfectly happy to suggest that we go along with the recommendation of the officer.
Thank you very much for that. Stephen?
I think we are at the nub of the issue, but I don't think it's as clear-cut as that. And as far as I understand it, outline planning permission is no longer, that's part of the history, but it's not in place now. Effectively, you've got vacant land that happens to be owned by somebody, but that's not the party that's making the application. So it's for a single development on a site. And I think that's the clarity that needs to be required, because I think the reason for refusal implies that there's a wider site, as if the historical outline planning permission somehow still carries some significance now, which of course it's expired. So what is the wider site in this sense? Is it just an area of land that happens to be owned by another party that isn't actually making the application? So I'm not comfortable with the assumptions in that reason for refusal, because I think it actually opens the can of worms that we're actually trying to get to the bottom of. And I'm not convinced either that this wouldn't fit into an exception case, given the sort of transition from the previous plan to the current LDP. But again, I'm just not very comfortable with the reason for refusal as it stands, and would be happier to sort of hear from the rest of the LRB.
Ian, you want to come in?
Yes, I would tend to support that point of view. I understand what Councillor Maitland said about the Stewardship Committee being against incremental building, etc. But this has happened at this site. It does have a history. I also understand the reasons for the LDP, or been included in LDP when it was adopted. And that should be adopted for new applications. But this site has a considerable history that has allowed incremental building. And I would certainly support Stephen.
Ted?
I actually agree with Councillor Maitland, you know, that the weight that's attached to the local development plan, you know, is paramount in this case. And if we don't actually go down that route, we allow for piecemeal development, which I think would be contrary to what we're trying to do. So I would actually support Councillor Maitland.
So this is the first one since the new local development plan has actually been brought in, and the local development plan was actually used to address some of the issues that are actually being discussed here today. Clark, how do we take this forward? So we've got a motion and an amendment. So do you want to proceed on that? Jane?
Could I be quite clear as to what is the amendment? It's not clear to me what the amendment actually is.
I'd like to seek clarification myself. I have a motion from Councillor Maitland, seconded by Councillor Ted Thompson, to uphold the recommendation to decision to refuse the application on the grounds set out at 5.1, page 18. The amendment by Councillor Stephen Thompson, seconded by Councillor Blake, is to reverse the recommended decision, and I presume you need to give grounds for reversing that, on what the reasons for that reversal is. The purposes of the minute.
Okay, thanks for that. I don't think I actually came out and made an amendment as such, but it was more to sort of raise the fact that I wasn't comfortable with the reasons for refusal as it stood. And then
perhaps then,
yeah.
Stephen, I could ask David to clarify the issues that you raised then, and perhaps that might take it forward.
Well, being honest, I can see there's a genuine case to be made for either view in this. Obviously, the appointed officer took the view that line in the sand and therefore contributions were required, looking at the greater area, which is within the same ownership of one developer, and it's a development which has a road network put in, the infrastructure's there. So I think the concern would be that if each plot was developed individually in isolation, then there would be no method of getting any developer contribution. You would just be accepting that that has to go. It's really just to tease out from yourselves, if you're minded to overturn the recommendation, is it to just approve the house on that plot with the fairly standard conditions you would expect to see in terms of the roads officer's comments, those sort of things? Or would you want to have it as subject to a legal agreement for a developer contribution at all? Because we've got, as I understand it, the motion is forward just to uphold the original decision, full stop. Whereas I sense there's an interest here in actually trying to approve it, but is it approve it with conditions, approve it with conditions and a developer contribution of any shape or form?
Okay, thank you. Yeah, that's closer to where my mind was sort of headed, having considered it, which was yeah, I see this as an exception in terms of the LDP and supplementary guidance, in that if it can be determined in such a way that it could be, that decision there could be reversed and either reconsidered so that there was a legal agreement, for example, although how that would be put in place, Section 75, I presume, and what the sort of quantum of that would be, but then that would be having to reconsider the whole application from the start again. And I'm not really sure how you would settle on what that contribution would be, or whether that would just go back to the to planning officers to determine.
Well, it can't go back to the planning officers. They've made their decisions, so really it sits now with the LRB. I mean, again, I'll probably refer you to page 27, where Mr. Taylor, as the agent, is actually, the last two paragraphs I think are quite significant, where he said, it's submitted that the proper approach to this application is that it should be granted with or without a financial contribution. So I think he's put that out there to yourselves as the LRB, and then made mention of Circular 3/2012, which is the one on planning obligations, setting out that the local planning authority is minded to grant permission subject to conclusion of a Section 75 agreement where a contribution is justified. Now, obviously, there's still debate as to whether or not any contribution is justified, but at least he's put that forward as an option to yourselves. What would have to happen is that if that was the way you were minded to grant subject to a legal agreement, then the heads of terms would be drawn up and sent out, and provided the applicant was willing to enter into that, then the permission would be forthcoming when the Section 75 was signed. Alternatively, you don't have to have that. You can actually just approve it without any Section 75.
What I was going to ask is, if we were to refuse it, presumably the applicant is in a position to come back in with another application, suggesting that they will go for a commuted sum. Is that the case?
Absolutely, yes. Within a year of the date of refusal, they get a free go application.
Stephen?
I mean, I'm minded to go with what the officer suggested there in terms of looking for determining to date, as in do away with that reason for refusal, approve it with Section 75, as per the suggestion on page 27. I mean, there is a notional figure set out which allows us to effectively, as an authority, accumulate contributions, as it were, and I think the recognised need was to do with education in this particular area, because I don't think the open space one was particularly relevant as far as I know. But then it would be up to us, if other sites come forward or other applicants come forward, then that could be a cumulative total to sort of recognise by some kind of exception. I just think this is effectively one that slipped through the net with the LDP, because you've got a planning in principle has expired, and it's allowed this to be open to this type of application and confusion, I think.
Yeah. I mean, the only concern I would have is we have a Section 75 agreement on this particular application, and then another one comes forward, and another one comes forward. Whereas if we go with the recommendations, it covers in that with a free go for the applicant to come back and try and arrange the the developer's contributions side of things that way. Understanding, of course, that it's not the other sites developers. David?
Again, I'll probably draw your attention to page 24, because the appointed officer is in paragraph 7. I think this is the solution, if you like, because instead of each individual applicant then having to enter into a Section 75 and make their own individual contribution, what you really need to send out is a message to the actual landowner. It's them that needs to sort this out, and therefore it frees up anybody to come in with an unfettered application for as it goes on. But the only way you can send that message would be actually to say, well, no, the planning authority is not going to grant you any planning approvals on this land unless you've sorted this out. That's, I think, the steer that the appointed officer is given there in paragraph 7.
Yeah.
Which goes back to my initial question about outline planning permission. So I would like to put the question, Chairman, do it.
Stephen?
Yeah, I mean, I think just from this discussion, it's clear that any amendment that would want to come forward with, it's not secure enough, given that there's a better way forward, I think. And much as, again, it comes back to sympathy for the applicant, but it does in one sense say, well, basically nobody can develop here until this other thing happens, so it kind of prejudices against individual applications, which is a concern. But here we are, and I can't get a satisfactory form of words that's strong enough to actually be a decent enough amendment to go against what's been put forward. That's where I'm at anyway.
So the motion is to agree with the recommendations and uphold the recommendations. Agreed? Okay, thank you. Okay, members, we'll go into item 5. That item 4 was the uphold of the recommendations for the officer. Notice for review for item 5, refusal of planning permission, principle for erection of dwelling house, information of access at land adjacent to Whitefields, Galla Hill, Gatehouse of Fleet, planning reference number 15P20030. As I did before, do you want to go through the photographs first, David?
Thank you, Chair. Again, just the slides that you have in the papers. This first shot just shows the road as you come out of Gatehouse of Fleet, and on the left-hand side you have the cluster of houses which are known as Hillfoot, Ardmore, Braeside and Whitefields, just beside the B727 public road. Obviously, we'll draw your attention to the block of trees and just to the centre right there, which is close to where the application site boundary is. So this has moved a bit further on. You've got the white gate piers on the left-hand side, are those of the house known as Braeside. And then just where the car is parked is the access to the following house at Whitefields. Moving a bit further around, that's just looking up to Braeside itself. And here you're hitting the end of the 30-mile-an-hour speed restriction, and you're looking towards the Cali Lodges in the centre of the photo there. So the application site just really sits in on the left of that photo. And it's just panning round from that, where you're looking across the site. And this is up in the site, looking back down to a house called Whitefields and down to the road, just to give the context again. So you can see it's quite a sloping site.
Okay, so before members will just go through the index of context. The notice of review and related documents is pages 279, 298. Sorry, yeah, 298. Any points of clarification? We have the report on handling determined under delegated powers and related correspondence, page 299 to 303. Any points of clarification on that? Jane?
Yes, 4.5 on page 303, Chairman. There is suggestion here there's little presence onto the public road, and it's therefore considered that the existing dwellings have limited relationship to one another. Is that one of the things that we consider is important in terms of our small building group policies? The fact that they don't actually have presence onto the public road?
David?
Well, the bottom of page 302, just the opposite page, gives the criteria that we have to look at, where it's defined as 3 or more separate habitable or occupied houses which are well related to each other and which create a sense of place. So really that's the nub of this one. Do these 5 houses create a small building group as we would recognise it? I think the point that the case officer appears to be making here is that only 3 of them front onto the road, and the other 2 are set back via a private lane, and therefore are querying whether or not this actually makes it have a sense of place, a sense of feeling. obviously she's come to her particular conclusion on that, which she thinks it doesn't, but that's, again, you've hit the nail on the head. That's the key issue for the LRB to consider today. Is it a small building group?
Yeah. The observations of the appointing officer and objector and applicant's notice of review, pages 307 to 309. Any points of clarification? Jane? Oh, yeah.
Yeah, sorry. Yes, it was in paragraph 4. The Sandy Hills application was out with the inset map area. Was Sandy Hills a small building group? Is that what I'm led to understand? Was it actually originally a small building group? It must have been. Because it talks about out with the inset map area, so how it can have been a small building group. There's a picture of it somewhere. I'll go back to it.
Yes. If you look on page 422, at the bottom paragraph there where it says the Stewardship Housing Market Area, then you'll notice Sandy Hills is identified as a small building group.
Thank you. And actual fact, if you look at the picture on page 296, Chairman, with the Sandy Hills proposal in the corner there, that must presumably have simply carved out. I don't really understand how it would have been, but it must have carved out that corner. Okay, thank you.
We then have plan application form dated 26th of January, plans and supporting documents, pages 311 to 336. Any points of clarification? No. Okay, and the decision notice from the Dumfries and Galloway Council dated 24th April 2015, pages 337 to 341. Points of clarification? And then we have the relevant extracts from the Dumfries and Galloway Local Development Plan, pages 343 to 423. Any points? Stephen?
Yeah, thank you. It's just on page 412, where it gives some examples of, I suppose, acceptable or unacceptable examples. So you've got, in particular, the top right illustration, which is a site contained by woodland and slope to create a site for a single house. And also in the bottom right, you've got point 3, development of a site that would round off that complements developments, in this case on the other side of the road, but you can see how that features in the applicant's position. So it was really just to understand how much of a aesthetic or subjective view is taken when by case officers. You know, that clearly there's a sense that this isn't sort of set in stone, but there's an element of intuitive experience at play here in terms of deciding these things.
David?
It is fair to say that in previous situation, case officers had a prescribed list of small building groups, which had been through at some length, sometimes through area committees, which had been agreed. And that therefore set a clear template. Since the LDP came into being and the supplementary guidance was adopted, we're in a different position as a council where we now find that it is possible to look at each case on its own merits and decide whether or not, okay, that's maybe not a site which had been considered for a small building group before, but it would meet the terms and there is a site which is appropriate within it. I mean, examples such as the one you've got, and they're not trying to be too prescriptive, it's just an illustration, but page 412, that one in the top hand right, I think you can see that site there, for example. It is a rounding off. You've got a clear backdrop with the escarpment going up to the rear and the wood. By putting a property there, I would almost regard that as a rounding off and an infill, where there are cases of a clear gap site, such as the top left-hand side, that equally is clear. Going the other way, extending a ribbon of development, bottom left, is something that would be discouraged. Where you're extending a ribbon of development, such as the bottom right-hand side one where it's marked 1, that's going out into open countryside, but you've got, again, got a defined one on the opposite side at number 2 where a road is bounding it. So that there is an element of, these are all the chewy ones that are coming before you today, I know. You have the wood, which that does act to some degree, but there again, you'd have to remember that not all trees remain forever. And if they went after that, the trees were removed, would that then be opening up another extension? It's not the same as a physical boundary, such as a road or a river, but clearly you do have some delineation going on there as a result of the that. So yes, in answer to your questions, it's a new era, and I think case officers are still finding their feet with it a little bit, but the supplementary guidance is providing at least some benchmark for how we should assess these things.
Jane?
If I've got it right, actually that woodland is ancient woodland, so it's protected, I think. So I think there's probably we could probably look at that and think that would be protected. But you know, this is all very fine and dandy, but actually what we've really got to decide is whether those 5 houses have a sense of place. That's, you know, I don't think anybody would disagree that that would be a splendid place to have, and absolutely concurs with somewhere where you would put a plot if that was a small building group. That's, I think, what we're going, but I'm possibly going ahead of myself. I know that you're still in the middle of this.
Anything else? Okay, well, we'll go to the grounds of refusal, which is page 340, that the proposal is contrary to policy H3 of the local development plan and to national policy is set out in Scottish planning policy, which permits the erection of new houses in the countryside only in special circumstances identified in development plans. And none of these circumstances apply in this case. In particular, the proposed development is not considered to meet the criteria for a small building group, as the existing houses are not considered to be well related to each other, nor do they create a sense of place. The method of determination, the applicant has requested that the review be dealt with by means of an inspection of the land, which is subject of the review. The grounds stated in notice of review, in summary, the site is well related to the existing distinctive grouping of 5 houses, which have a shared sense of place. The proposal provides a logical and consolidating extension of that grouping. The robust boundaries exist on all sides, including a strong woodland boundary to the south, preventing further expansion and containing a small building group. The access would be safe, and the council roads officers raised no objection to the proposal. The principle of the development complies with the provision and intentions of LDP housing in the countryside policy, subject to design to be assessed in due course. The proposal would not have a negative impact on the Fleet Valley National Scenic Area, and in comparison with permitted planning applications 13P20016 and 14P20150 relating to small building groups, it is asserted that the physical characteristics of these groups were less robust than this, or directly comparable with the situation at Galla Hill. Each case has to now be considered on its own merits, rather than already be an identified small building group considered suitable for further development. There are comments from the roads planning officers, and the development plan policies that we will look at are OP1, development considerations, OP2, design quality of new development, H3, housing in the countryside, NE1, national scenic areas, NE2, regional scenic areas, and other material considerations, Scottish planning policy, draft supplementary guidance, design quality new development, housing development in the countryside. And the main issues for the local review body to look at are: does the proposal conform with the relevant development plan policies, and critically, does it comply with LDP policy H3 in principle? Does the proposal comply with the relevant guidance set out in the consultative draft supplementary guidance, housing in the countryside, now adopted? Why did you put that? If not, are there any material consideration which would indicate that planning permission should be granted as an exception to policy? We've outlined the documents in the members' paper. It now falls to us to determine whether it has sufficient information to consider the review. It is confirmed that no representation from any party will be held today. And if members are clear, and if no further clarification, I'll ask the members to discuss and debate the application. and hopefully come to a conclusion. Members, over to yourselves. Jane?
Right, well, I think it goes back to the first question. Are those buildings on the outside of Gatehouse a small building group or not? I suppose I know that area reasonably well. They were simply built on the edge of the town, probably mostly before there were any planning regulations at all, and they were built there, I think, in order to enjoy the view. I don't think there is a nucleus to that particular grouping. I am afraid I see them as just a series of individually designed houses on the edge of Gatehouse. I have considerable sympathy because, as I say, if that was a small building group and could be considered to be that, there's a jolly good place to put another house. But in terms of our policies, Chairman, I don't think that we could really say to ourselves that grouping of buildings has got a nucleus and a sense of being a cohesive lot, cohesive grouping. They are kind of, they've grown up, as I say, because of where they could look out. I think I should say that actually I disagreed with the Craig Bitton recommendation and decision at Sandy Hills. And I remember I wrote to the planners at the time to raise questions. So although we actually are not, the agent has raised that as one of the issues, I personally disagreed with it at the time. So I think I'm being totally consistent in that. And I thought the policy on small building groups was too open at the LDP, if you might remember. I wished that we'd had clarity and discussion about what was or was not a small building group and a list, which would have made things much easier and happier for everybody. But we haven't got that. So we've now got to decide on a case-by-case basis. I take the view, unfortunately, that I do not think that this constitutes a small building group. And if it does not constitute a small building group, then this proposal falls.
One of the things that under HC, there's sort of 5 bullet points of why we would go in favour of or overturn. We want to know what those 5 bullet points. Do you remind us, David?
Yes, I mean, to be acceptable to be a house in the countryside, you've either got to be one or more of the following criteria, which is within or well related to a small building group which is either identified on lists contained in supplementary guidance or defined as 3 or more separate habitable or occupied houses which are well related to each other and which create a sense of place. You can demonstrate that it's essential for the needs of agriculture or other business requiring a rural location which cannot be met in a nearby settlement. And no such claim has been made with this application. It's a single house associated with a retirement succession of a viable farm holding where there are no buildings suitable or economically viable for conversion to residential use on the farm unit. Again, no such claim has been made. Beneficial redevelopment of brownfield site. It's self-evidently not a brownfield site. Replace or renovate an existing house with a house of an appropriate scale within the same curtilage. Well, there's no house on that site. Conversion of a traditional building. Again, there's no traditional building. So the only possible criteria which could be used here is the first one, which is that it relates to a small building group.
I'm of the same opinion as Jane on this matter, and I would propose that we... Ian, you want to come in there?
Yeah, I'm not certain on this one. I understand that it didn't set off to be a small building group, but nonetheless, you've got a group of houses that are featured together. and are bounded by what we've now discovered to be an ancient woodland that won't change. So I've got a site within a group of houses that it appears to be a small building group. So I've got reservations on it.
I think the situation for me is that obviously that might be an ancient woodland, but we haven't got that confirmed in any way whatsoever. So therefore, there's a potential for that. Is there a TP on it, for instance? You know, there's all sorts of things that can move forward on that side of things. Do you want just to make a recommendation of sorts?
I would like to see what some other members feel about it.
Ted?
I think the question that we have to ask ourselves here is does this consist of a small building group, and does it have a sense of place? I think Councillor Maitland probably identified that the houses that were built there originally were built on the edge of the town, and they were built specifically for the viewpoint that they provided. So my view is that it is not a small building group. It does not have a sense of place. So I would support Councillor Maitland on that.
Stephen?
Yeah, just a minor thing. Obviously, this is within the 30. So is it or isn't it out with the settlement would be one question. The other thing would be, however houses have come to be, what they are now, you know, they might have all grown up individually for various reasons, but a sense of place isn't something that you start off with. It's something that emerges over time. And I think that what's there now, whatever its origins might have been, could, and the case has been made that that is actually could be considered as a sense of place. It doesn't need to have a nucleus as such, just buildings that well relate to each other and create a sense of place. Now, that sense of place could emerge because of what has been there for such a long time, and it's become considered a kind of place or a setting or whatever it might be. So I think there is an argument to be made. So I don't think it's as clear cut. But just on the 30 mile an hour limit, I'd appreciate a wee bit of clarity about that. Thanks.
David?
Yes, just that's the photo there again showing where the 30 mile an hour limit is. A 30 mile an hour limit is there for policing speeds of vehicles, effectively. It is not there to actually define where a settlement boundary is. And therefore, a 30 mile an hour zone does not actually say that you're within a settlement boundary. Just for information, that is the LDP extract. You'll probably not be able to see it from that distance, but this is it for Gatehouse of Fleet. With the black line that runs round it is the actual settlement boundary. And this collection of buildings here lies specifically out with the settlement boundary. So it's really regarded as a whole outlier, very close to, but not within the settlement boundary, which is another thing obviously to bear in mind because it is so close to Gatehouse. Does that actually give it its own sense of place? Normally, small building groups are a cluster of buildings which sit in open countryside that have a distinct identity in themselves. My own view is that this is an outlier to Gatehouse.
If members would like to go to page 157 or the 600 of the previous application, the Gatehouse of Fleet is there.
It's there, right. Okay.
So you just show us where it is now?
Yes, that's it there.
Right side, yeah. If you see,
Just
sorry,
immediately
member.
to the...
If you see Gatehouse, where it's written Gatehouse of Fleet on the right-hand side of that particular page, in the centre there, GOFH2 is to the left of the group of buildings. Where the writing says Gatehouse of Fleet and GOFH2, it's in the centre there.
Sorry, I didn't catch your point, Chairman.
So it was David was trying to show you where it was on the policy. I was saying there's a map in here that shows the same thing. That's page 157 of 600.
Thank you.
Stephen?
So are we basically trying to decide whether or not it is or isn't a small building group? And is that a matter of opinion?
I think does it affect with policy H3 is what we're asking at the end of the day, because it's housing in the countryside. And I think small building groups have a lot to answer for, because of a lot of problems over the past. And in effect, what we have under the local development plan is 5 reasons why we can have housing in the countryside. And if one of those reasons actually fit, one or more of those reasons actually fit, then it would be looked upon favourably. What the appointed officer is saying is that they did not agree with that. So there's a suggestion that we go with the recommendations from myself and Jane and Ian.
No, I still feel like it is a small building group. It's quite clearly identifiable. You've got a group of housings to get together. I appreciate that it didn't start off with that purpose, but neither did probably any other small building group in the country. It probably started off with 2 or 3 houses, and then an additional one was built. This is one that you've got a clearly identifiable boundary, and I would actually approve it.
Stephen?
Yeah, I'll support that.
So I'm quite happy to put the motion forward. We go to the recommendations. Jane, will you second that?
Yes, I'll
and then
second
there
that.
is an amendment to approve the application and grounds.
As it forms part of a small building group.
David, can you help?
Yeah, well, I mean, it is one of those ones where there's not a policy issue. It really falls down to an interpretation as to whether or not it's a small building group. And clearly you've stated reasons here, which is that it is, I can confirm, if you look on page 301, I'm sorry, I missed that earlier, this is an area of designated ancient woodland on the southern boundary, so it confirms it is that. So that's perhaps the justification that you'd be wishing to put forward, that there's a clear boundary at the southern edge. Can I just check, would that be approval subject to the standard planning permission principle conditions and directives, and I would suggest roads conditions that you'll be looking at on page 305 and 6? Are there any other conditions you'd wish to attach in terms of citing design materials, size, anything like that?
No, I'm quite happy with it.
So we have a motion and
The motion, Chairman, is to refuse the application on the grounds set out in the report. The amendment is to approve, subject to conditions, and on the grounds that the existing grouping constitutes a small building group and has a sign of place. Chairman, motion or amendment?
motion.
Councillor Blake?
Amendment.
Councillor Maitland?
Motion.
Councillor Stephen Thompson?
Amendment.
Councillor Ted Thompson?
Motion.
Motion is carried by 3 votes.
Thank you very much, members. So the application has been, the recommendation has been upheld. We'll go on to item 6 now, which is notice of review, refusal of plan, permission and principle for erection of dwelling house, information of access at Garden Street, Gatehouse of Fleet, plan and reference numbers 15P20052. As before, I'll ask David to go through the photographs and we'll go through points of clarification in the context. David?
Thank you, Chair. This is looking down Garden Street, past the property that's known as Medstead Lodge. So it's looking down towards Fleet Street. So the application site is, looking at the pointer to work, it's sitting somewhere in around here in line with this relatively modern property there. This is moved further down so that you're looking down again towards Fleet Street and you're seeing just the edge of the new property sitting in here. So the application site is just sitting in the centre of that photo. and this is moving across, so you're just looking straight down with the boundary of the conservation area is down the middle of the road, so everything to the left on that photo is in the conservation area and the boundary to the right isn't. So the application site is within the Gatehouse of Fleet conservation area. This is turned around 180 degrees. You're now looking up Garden Street, and sorry, those with local knowledge will probably know. That looks like the surgery to me, and that might be the school that you're just seeing the tip of. So again, you've got the new property you're seeing just here, and the proposed house would be in line with that behind this hedge. So presumably the hedge would have to come out to actually get access in. That's looking across the road from the application site, and the next photos move into the application site. So the house would basically be built in this area here, and you can see again the hedge for visibility reasons, so I suspect would have to come out. Again, just looking round into the plot.
Thank you for that. And we just go through the contents for clarification. The notice of review and related documents, pages 435 to 446. Any points of clarification? Jane?
Yes, I'm sorry, I don't know where it is, but there is a question. Ah, yes. I'm sort of slightly confused about our previous, on page 441, Chairman, in section 8, statement setting out reasons for review, it is an application in principle which is generally in keeping with our previous successful application, 96P 2000-20075. And I'm not absolutely clear which application that was. It wasn't the lodge. So can I have some help on that?
David?
Yes, Chair. Basically, if you look on page 445 and 446, you've got plans there that I understand were approved previously for a plot on this site. But obviously that was a historical permission which has subsequently expired and therefore never been implemented.
Jane?
Oh, sorry, Chairman. Thank you. I now see, because actual fact, the stamp says 13th of July 2015, but if you look above in the red stamp, it's 18. Thank you. Thank you very much.
Thank you. Report on handling determined under delegated powers and related correspondence, pages 447 to 452. Any points of clarity? No. Observations of point officer and objectors on the applicant's notice of review, pages 457 to 459. No. Comments of the applicant on observations of the point officer, pages 461 to 446, 464, sorry. Plan application form dated 12th February 2015, plans and supporting documents, pages 465 to 487. Decision notice from Dumfries and Galloway Council dated 13th, pages 489 to 493. And then relevant extracts from the Dumfries and Galloway Local Development Plan, pages 495 to 591. And then we've seen the photographs of the site. So the grounds of refusal on page 492 is the proposed dwelling house will be contrary to local development plan policies OP1, OP2, HE2 and the Gatehouse of Fleet Conservation Area character appraisal, in that it would not preserve or enhance the character and appearance of the conservation areas, nor respect the established historical layout and patterns of the development of the area. Request method of determination, the applicant has requested that the review be dealt with on the basis of an assessment of the review documents only, with no further procedures. The grounds stated in notice of review, in summary, is 1, the proposal is in keeping with supplementary guidance for Gatehouse of Fleet Conservation Area, in that it does not involve reuse of older buildings, it is not a pastiche, and is sensitive to its context. I'll have to look up that one. The in-principle design submitted takes the existing built environment into account with regards to massing and refers to Medstead Lodge with regards to the possible design of a dwelling. Regarding the pattern layout of the area with Medstead Lodge and with Caravan Park, Gatehouse Surgery at the end of Garden Street, a very modern building of recent construction, and the school behind that and the community centre, it's very hard to see that this is an area of anything other than mixed development. What is being proposed in principle is both reasonable and essentially sympathetic within a context of mixed buildings establishment and fits with the supplementary guidance. It is in line with Medstead Lodge and taken into account would not stand out in that relationship. It would not look out of place, therefore, in this leg of Garden Street. It would allow for a new dwelling within Gatehouse of Fleet with very low impact. We have further comments by internet parties within the documentation and the development plan policies. Obviously, local development plan, OP1, OP2, H1, HE1, HE2, NE1, NE2, IN9. Obviously, Gatehouse of Fleet Conservation Area character appraisal and draft supplementary guidance. Design quality of new development, material considerations, the Scottish Historic Environmental Policy, Scottish Planning Policy. So the main issues for the local review body to consider is, does the proposal conform with relevant development plan policies, and critically, does it comply with LDP policies OP1, OP2 and HE2? Does the proposal comply with the relevant guidance set out in supplementary guidance Gatehouse of Fleet Conservation? If not, are there any material considerations which would indicate that planning permission would be granted as an exception to policy? Within the papers, it outlines the documents. It now falls on the LRB to determine whether it has sufficient information to consider the review. It is confirmed that no representation for any part will be heard today. So if members are clear, we'll get into the debate. Any member? No member? Ted?
I think the case for refusing the application has in fact been well made.
Thank you very much. Jane?
I think we should also actually consider carefully that these policies, the policy on the gatehouse appraisal, is less than a year old than when we adopted it. I think the critical word is historic. I don't think this does conform with the pattern of historic pattern of development in Gatehouse. Medstead Lodge was, I think, a mistake, and I don't think we should compound that mistake by changing the pattern of development, which pushes across two of these long gardens, and I just think that would be the wrong thing to do.
Thank you. No. So, as I'm concerned, the motion is to uphold the recommendations of the officer. Are we happy with that? Okay, thank you very much. I have no further business. David, unless you've got anything?
No, that's fine. Thank you.